All right, so tell me, how are
I'm
you
good,
doing?
and you?
All right, I'm doing very well. So today we're going to be discussing some very important questions that connect both Nigeria and Brazil. And as we go through these questions, you'll be giving your opinion, your perspectives about these topics, and that will basically be interview. So for the first question, um, right now in Nigeria, there are several reports of police brutality, reports of unlawful detention, excessive use of force,
Mhm.
you know, and these things still happen even in today's, in present day Nigeria. So the question I want to ask you, from Brazil's experience with police accountability, what legal mechanisms could actually work to control, this abuse of power?
Mhm, mhm. Yeah, thank you for your question. And I think this is a challenge that Brazil knows very well. So I will answer this with some. Brazil, to be honest, is far from having solved police violence, but there are some tools that this the international law principles only start to matter when they are translated into procedural pressure points. One example is the early judicial oversight of arrests. So custody hearings, the ICCPR protections forcing state. Another lesson that we have here is the independent oversight matters more than internal discipline. And what I mean by that is that Brazil's constitutional role for prosecutors to externally control police activity reflects core international rights, and they try to implement investigations into abuse, and these investigations they must be independent from the institutional accused from the institution accused. So when or where this oversight is weak or politicized, abuses continues because the probably the institution that is being accused of committing rights violation is doing the or excessive use of force, that it's still something that happens around the world.
Okay. Um. Okay. The thing is, with the kind of system, or okay, let me just present it this way. One of the issues that Nigeria actually has as regarding this, right? The fact that the police are actually underpaid. That's one of the big issues. They are under, or I can sort of see where, because of the lack of funding, the lack of proper training as well. A lot of persons may not necessarily be uh, or even have any skills in like diplomacy, and then they are conscripted into the police force. They have to and they don't have to, they don't actually go through a kind of training that actually teaches these kind of skills. I don't know, does Brazil have anything like that?
Yeah, I think we actually have a similar problem. We have a huge police force because Brazil is a huge country. But when it comes to diplomacy or how to handle hostage situations, when I say hostage, let me reframe that. When we're dealing with police force, we training police officers the way we should be training them. We are more reactive than proactive, and what I mean by proactive is that police force reacts or acts before trying to go for a more peaceful way of engaging. So I feel, especially in some regions in Brazil, we have the same issue. I don't think handle situations differently, not engaging in a violent way as a default. I think those are things that the police force here also in Brazil could benefit from, because we see on a daily basis on the news how brutality within the police force is being used against people. So I definitely think that is something that we should improve as well. But from a legal perspective and from a process implementation, we do have some tools to safeguard those police brutality situations, especially after the arrest. Even though crowded prisons is a huge issue in Brazil, but we actually have some tools to prevent that after the arrest. But for before the arrest, that is actually an issue that we are facing as well, because in general, police force, they don't have a proper training when engaging with people. Instead of using brutality or force itself, they should have a different approach. So I think we are kind of like on the same boat here when it comes to Brazil and Nigeria, because it's something that we see every day on the news and we see every day on the street as well. So yeah, I do think we could both benefit from a longer and proper training when it comes to dealing with people and not using violence, brutality, or force when it's not necessary.
All right. Great. I love that. Okay, so let's go to the next question. So there are many victims of human rights violations, um, and you have some experience in humanitarian affairs and dealing with human rights issues. So there are many victims of human rights violations in Nigeria, and a lot of these issues, they never get to go to court. And even if they do go to court, the legal cases could go on for years, for long periods of time. A lot of times they can't even go to court because of costs, legal costs. A lot of them don't even trust the legal system anymore. A lot of people fear the legal system. They feel like it's not, justice isn't actually just anymore. So the question I want to ask you now: how can a country actually build a legal environment where victims of human rights violations will feel safe to seek justice? Yes.
Yeah, I think your question is really point on, because I think that justice goes further than spelling out what victims actually need. They need, in practice, they need safety, dignity, access to the justice system, and protection from retaliation. And that's something that is lacking in a lot of jurisdictions around the world. And what this tells us is that access to justice is not just about having courts, because we do have courts that work, but it's about designing a system where and risks of speaking up are lower than the cost of silence, because those, I think, are the main points why most victims, they don't seek justice through the justice system. In some, I think we have to treat this as a system design problem, and not as much as a moral one. So I think people, they don't avoid course because they don't care. They avoid course because the pathway is risky and expensive. So for countries
Oh,
to deal with that, I think, and especially to build trust, because for me, trust is the main thing that is lacking, is investing in legal aid and simplified procedures. So justice is not reserved and independent complaint mechanisms, especially for violations involving state agents, because there is a fear of retaliation. And of course, strengthening with witness and victim protections framework that actually function, and also the speed, because when we are talking about justice, we have to talk about the speed or how fast the procedures are, and because remedy that takes years, they often feels like there is no remedy at all. So from Brazil's experience, it shows that when victims, they believe that complaints will be ignored, or will expose them to retaliation, or it will take years, which is actually what happens, they simply disengage and they don't feel compelled to use the justice system. So I believe that the real test here is whether institutions behave consistently and predictably, and not whether rights exist on paper. It's more on the design and the structure of the institutions rather than what they have as a process.
okay. All right. That was a brilliant answer. Okay, I believe we can actually move from that question. So now the third question I have for you. So Nigerian prisons are overcrowded. That's just a fact. They're overcrowded, with inmates. They're overcrowded with persons who may not even be guilty for whatever offense they did. Some are awaiting trial, and they've been awaiting trial for years. You know, what human rights based prison reforms has Brazil attempted, if any, and how can Nigeria learn from those lessons?
Yeah. So being 100% honest with you, Brazil's prison system faced a debt crisis. So I wouldn't
Wow.
frame it as is Brazil as a success story, but Brazil
Okay.
has attempted some reforms that I think are directly linked to your question and to some international standards, and offer some important lessons that could be reapplied. So I'm going to frame here from a international human rights perspective, where the International Covenant on Civil and Political Rights, and also the UN standard minimum rules for treatment of prisoners are very clear.
Okay.
Pre-trial detentions must be exceptional, lawful, and time limited. And I think
Hmm.
this is directly linked with your question, because you mentioned that a lot of people who are in prison right now, they might be innocent, they might have not faced a trial before. So and I feel that normally that's the default instead of the exception, right? So from our perspective, or from a Brazilian perspective, I believe that custody hearings were introduced in Brazil precisely to give effect to this principle. So, to reduce unnecessary detentions and ensure early judicial reviews of the cases. And also, Brazil has experimented with how can I put it? Large scale cases review initiatives, more like task force, to
Okay.
identify people who should never have been detained, or who have remained in pre-trial detention unlawfully. I think the key lesson here is that overcrowding is rarely a prison management problem, is more a criminal procedure failure. And
Hmm.
without strict limit detention, or alternative to custody or you, prisons they become storage facilities for legal delay in direct violation of international standards of human rights. So I hope that helps.
It does actually. Okay. So essentially, it's more about the legal system itself not being, expeditious enough to deal with, these cases, as opposed to the prison systems themselves. All
Yeah,
right.
I think it's the two things, and it depends on how
Okay.
the prison system is built. But here is state owned, is not private,
Oh,
so
okay.
I cannot link it from the
Yes.
judicial system itself. But
Okay.
it
Okay.
would be another thing if like prisons would be if prisons were
Okay.
private. So I think yeah.
Oh, okay. Okay. That actually leads us to another question, though not one of the ones I plan to ask, but I will still ask. So, would you prefer that, most prisons were privately owned as opposed to, state owned
I don't
or
think
privately run?
yeah, from my perspective, I don't think that's the best option for you to deal with a human from a right-based approach. Why?
Okay. Why?
Because we know that corporations they have their own goals, and
Yeah.
sometimes those goals they can and may violate human rights. We can see that
Yeah.
happening. For example, I'm going to use the US as an example here. The most prisons there, if not all, I'm not 100% sure here, are privately owned, right? And we can see some of the same issues happening there.
Yeah.
So I don't think, or even in another level, because here I think having the state as the main party responsible for prisons, even though we have a lot of issues regarding overcrowding, unlawful detentions, ill treatment of prisons, I think it's more, I want to say controlled if it's state
Okay.
owned, because then we know how to pressure. But
Yeah.
if it's privately owned, we are dealing with a lot of different interests for human rights defenders to use state-owned prisons as a point pressure or with leverage to leverage them instead of using company or private owned institutions where detainees are sent to, because that's another level of complexity that I think is not useful when we're trying to use a rights-based approach.
Okay. Okay. Perfect. Although on the flip side, someone may argue that where the prison systems are, privately owned, there will be more competition for, having say the best prison systems, or having the most facilities, the best resources, and it could actually create, better prison environments, better environments for, the inmates, and actually, cause reforms. Because as it stands right now, with the state-owned prison systems, state-run prison systems, there's really no reforms. Prisoners, in fact, persons who are not as, hardened, so to speak, or as tough, when they go into the prison systems, they come out tougher, they come out hardened, they come out, more resolute to do whatever they want to do. So, someone might actually argue that privately owned prisons might actually cause better competition, which would cause better environments, which would cause better reforms, which might actually be advantageous to the inmates. So that's just another side to the whole thing. But it's fine. We'll move
To your
on from
point,
that
and
particular
I agree
question.
that, yeah, I agree
All
that
right.
might
So
actually happen, but I think resocialization is something that should be implemented throughout like the prison system, either private on or state on prisons, because it's something that should be done as a rule and not as an exception. that could happen, but also I might argue that's not something that we see normally, because we do have a huge sorry to go back to the question, but we do have that system being implemented in one of the most influential countries in the world, where they say that democracy is at its peak, but we actually don't see that in practice. So
Mm.
where are we failing the judicial system or the prison system? I understand your point, and I agree that at some level that might happen. But if we take into account what we are seeing in practice, that's not
Yeah.
what is actually happening. But yeah, it's a totally relatable argument.
All right. All right. Brilliant. Brilliant. All right. So we'll move on to the next question. Um, so peaceful protesters in Nigeria, a lot of times they face arrests, they face physical abuses, citing and this police or law enforcement officers would cite public order laws, for the peace, or to preserve the peace and all that. Although even though peacefully protesting is a constitutional right. So how should the law balance national security with freedom of expression and assembly? Actually, there is an event that happened in Nigeria. It was tagged the NSAS protest. It happened in Lagos, at the Lekki toll gate, and it was a pretty widespread and popular issue. On the one hand, the law enforcement agents were saying that they had to take steps for security reasons, for the peace, for protection of property and lives, but a lot of lives were still lost that day, and these lives were peaceful protesters. These were persons who were protesting against the SARS. They were looking to end police brutality, and then they still met police brutality. So what do you think about laws balancing these two extremes?
Yeah, no, I think that's a really key question here, and international law does not treat this as a neutral balance. So,
Okay.
under the International Covenant on Civil and Political Rights, again, freedom
Okay.
of expression and peaceful assembly are the rules, and restriction are the exception. And this also has been clarified by the UN Human Rights Committee, Committee General Comment number 37, if I'm not mistaken, which makes clear that public order and national
Okay.
security cannot be used as. So the legal test is strict.
I'm sorry.
So
I didn't. I'm so sorry. I didn't get that last part. That they cannot be used
as a vague justification for suppressing dissent,
Okay.
because
Yeah.
that's what normally happens, right?
Yeah.
And in my opinion, like, the legal test here is that restrictions, they must be lawful, necessary, proportionate, and non-discriminatory, and
Mm.
also it should be subject to fast judicial review. I think it links to what we have been discussing before, and here in for example, in the case of Nigeria, countries that fail by drafting overly broad public order laws that give authorities excessive discretion to make arrests, bans, and literally violating the rights to freedom of expression and peaceful assembly, are wrong. So if the law allows
Yeah.
preventative bans or arrests without clear necessity, it ceases to protect security or the public order, which is what they have been arguing, and it starts protecting power from criticism. And I think that's also linked with the system that we have, right? So it impacts on the government basis, and how people can actually express themselves to say if they're happy or not about something that is affecting them. So yeah, it's something that also happens here, and I think a lot of human rights defenders and and citizens, they face it on a daily basis around the world. But from a Latin American perspective, human rights defenders, including those that are pro freedom of expression, peaceful assembly, especially when they're going against the government, they face retaliation over and over again. Yeah.
All right. All right. That's brilliant. That's absolutely brilliant. Um, all right. So now we're going to go into another set of questions. And these questions will be targeted majorly at vulnerable groups and social justice. So the first question in this set: there are internally displaced persons, due to terrorism, banditry, and these persons often lack access to, good housing, education, food, water, as basic as water, and some other legal remedies. What rights-based framework should Nigeria adopt to, better protect these displaced citizens?
Yeah. So I think there's already a comprehensive framework in place when it comes to international law. So at the global level, the UN Guiding Principles on International Displacement is a good one to start, which affirms that internationally displaced persons, they remain full rights holders, which means that they still are entitled to their rights. And I think at the regional level, taking into consideration that we are talking about Nigeria here, the African Union Convention for the Protection and Assistance of Persons in Africa is legally binding and particularly relevant for Nigeria. Both frameworks, they cover displacement caused by armed conflict, terrorism, development projects, and place the primary responsibility for making sure that these people have access to the rights on the state. So together, I think these two frameworks, they require prevention of displacement where possible. We know that sometimes that's not something that can change, especially related to, for example, armed conflicts. It's something that we cannot stop sometimes. But the main point is that protection during displacement, access to services such as water, housing, jobs, standard of living, and also remedies should be durable. They should be done throughout the whole process of displacement until they are accommodated in the final destination. So treating displacement purely as a humanitarian issue, I believe that it ignores the legal and governance dimensions of the problem. So here I would say that there has to be legal status recognition and documentation. So without documentation, people cannot access service or remedies. And this is super important when we are talking about displaced communities and people, because sometimes they lose their documentations when they are being displaced. I also think that the minimum standard for housing, education, healthcare, livelihood support should be clear that the responsibility lies within the state. And also to provide proper grievance and remedy mechanisms that have to be accessible provide legal aid, because normally people who are being displaced, they do not have access to the amount of money, as, and we go back to one of the first questions, to the amount of money that they would have to seek justice in the judicial system. And the state should also implement protection against groups are always facing more exploitations. So, in a nutshell, a strong framework also clarifies coordination. So, who does what, with what budget, and under what timeline. So, those are the main points when it comes to displaced people.
All right, brilliant. All right, we will be. Thank you so much. Your answers are, precise and insightful. We're going to be taking a very short break, and when we
Okay.
come back, we're going to be talking about um, sexual violence and vulnerable groups such as women, girls, and young children. And we will be back.
Okay.
All right, so Tammy, welcome back.
Thank you.
All right, we'll be going straight into the next question. So, women and girls in Nigeria, they face high levels of risk for sexual violence, and there is also another issue with low conviction rates for offenders. What legal strategies would be able to improve investigation, improve prosecution, and survivor protection? And let me also add another question with that. What legal remedy, so to speak, would also help to secure these victims? Because one of the major issues with this type of issues is, the stigma that is attached. Even if the person was to, go further with, legal prosecution and all that, there is still that stigma. So, what legal remedies could be put in place to actually, help alleviate that?
So to start with, low convictions rates, they normally reflect a systemic failure. So in investigations, evidence gathering, and also, as you were mentioning, survivor protection. Not a lack of crime, because we know this crime exists, but the system actually fails the victims.
Yeah.
This is due to the fact that many cities are designed in ways that discourage reporting. What I mean by that is that we know that women and girls and children, they can actually report the crime, but once they go to the police station, they get scrutinized, they get blamed, they don't actually get the help that they're seeking and that they're entitled to. However, we can mention potential strategies that might actually move the needle, such as specialized investigative capacity, so trained investigators, forensic capacity, trauma-informed interviews. So also having a woman doing the interviews or doing the reporting, or being the person that receives the victims of sexual violence in those police stations, because they feel more empathy and they might be able to deal better with the situation. But of course, we have to mention training. Being a woman doesn't mean that you're gonna know how to deal with the situation. It might be better, it might be easier for the victim to share their experience with you, but everyone should be trained on how to deal with sexual violence reports and crimes. Also, on survivor protection, I think restraining orders, they should be strengthened, because we know that there is this legal tool, but sometimes a lot of women who have been the victim of a stalker or sexual violence, they have a restraining order, but they're still stalked by this person. They are re-victimized by this person. The safe shelters that it's something is also something that happens, but they should be strengthened. Their location should be kept, let's say, in secret, and confidentiality protection should be strengthened as well. And protection from retaliation is something that we were saying, because a lot of people, a lot of women or sexual victims of sexual violence, they do not use the justice system because they fear retaliation and stigmatization. I think also that fast track procedures, especially for those cases, it's a must, because delay in those cases is a form of denial. So it's something that it's basically the system saying that they don't care about what you've been through. And of course, accountability for officials who mishandle cases, because it's also something that we actually see quite a lot, especially when it comes to situations where sexual violence or abuse are involved. I think it's important to highlight that these are not policy preferences. They are legal obligations under international law that the state should be applying or implementing. Basically, if you want convictions, you need to build cases with integrity. And if you want reporting, you need a system that generates, again, trust and safety and dignity for the victims.
Oh, that is a very pristine answer. Okay. A follow-up question to that, though I already asked it, but than perhaps remedies.
Yeah. So
Other than legal.
sorry.
Okay, you
No,
can
go
go
ahead.
on.
Go ahead.
Okay, all right. Other than legal remedies, are there ways that victims of these kinds of issues, persons who have faced this, are there ways that, other than legal remedies, that could reduce the stigma around them, that could be implemented on a wide scale, that could actually make a difference?
Yeah, I think that's a good question. And my answer is going to be, we have to change culture. I mean, general, because normally victims of sexual assault, they are blamed for being the victims of sexual assault. So what were they wearing? Were they provocative? Were they walking by themselves at night? So we have to change the culture. We have to change what people think about sexual abuse and violence, because sometimes that happens within the household of the victim. Sometimes it's a parent, is an uncle. So we have to change the culture to stop blaming the victim and start blaming the aggressor. Other than that, I think that therapy, I think support, psychological support is something, but is a remedy nonetheless, because those people, like any people who get their rights violated, especially in those situations where the violation is it's physical, it's moral, it's everything, is social. They need support. They need psychological support. So having an institution or an institutionalized organization or something similar to provide psychological help for victims of sexual abuse might make a huge impact on their lives later on and on the society itself, because we know that if the society or victims of any rights violations the society cannot improve. Like that part of the society cannot improve. So we have to think of them as the victims and not as the offenders, because that's how some people see victims of sexual abuse as the offenders. So we have to make the switch. We have to have a different cultural approach for those kind of violations.
All right. Thank you so much. That was beautiful. Okay, so we'll move from vulnerable groups into corporate responsibility and environment. Now, there are communities in the regions where Nigeria produces oil,
Yeah.
that reports a lot of environmental damage. This damage affects health, it affects livelihoods, it affects property. You know, now how can human rights laws, or can human rights laws be used to hold corporations accountable? You know, in this regard.
Yeah, perfect. I think the international law already is doing that, but let's backtrack a bit. So when we were
Okay.
talking about environmental damage, in especially environmental damage in general terms, but in the situation where you mentioned the oil producing regions, which is something that happens a lot in Nigeria, as you stated, we are not
Yeah.
talking only about pollution. As you just said, we are talking about human rights impacts that includes violations of the rights to health, clean water, food, housing,
Yeah.
culture,
Yeah.
livelihood. So, from a
Yeah.
legal perspective, the link is very well established. There is a violation. And under the UN Guiding Principle on Business and Human Rights, states have the duty to protect human rights, including when it comes to human rights violation triggered by companies. And it also has to ensure access to effective remedies when violations occur. So the international framework is already stating the state responsibility, right, or the state duty, but also the international law makes something very important clear. The companies themselves have the responsibility to respect human rights, independently of whether the state is able or willing to enforce the law. This means that the corporation must identify, prevent, mitigate, and remediate human rights impacts that are linked to their operations, products, or business relationships, including environmental harm that affects communities, such as in the case of the oil producing companies in Nigeria. And this is no longer just voluntary or reputation issue, shift, especially in Europe, that is changing how global companies operate, basically. So new frameworks, such as the mandatory human rights and environmental due diligence law, means that companies that want to access European markets, financing, or have new business or maintain the business partners that they have, they must demonstrate that they're preventing and addressing human rights harms across their global operations and supply chains. This includes the companies that are operating in Nigeria, in oil producing regions, or in any other sector, because we know that high impact sectors, they have impacts, but they have to deal with those impacts. So in practice, this means that environmental and human rights damage or violations, which is like the scope here of the question, is no longer a local problem. It can trigger legal, financial, and also market consequences, not only in Nigeria, but also abroad, including civil liability, exclusion from contracts, and regulatory sanctions. So, from the international human rights law perspective, especially in this new global regulatory context, this is becoming a tool not only for justice, but also for reshaping corporate behavior, where companies, they have to deal with the impacts that they cause, including in those situations in Nigeria. And we can mention that all the international courts, they're also judging cases that did not happen in that country. We can mention, for example, BHP that was sued
Yeah.
in the UK for the damage that they caused in Brazil, for example. So there is a shift in the international community when it comes to making companies responsible for the violations that they have committed when operating in an area, for example.
Okay, I think that's beautiful. That's an excellent, you know, answer to that. I strongly believe that all these that you have said will be, you know, implemented. Okay,
Yeah.
so another question in along the same lines. Whenever there are large development projects, projects that are, commissioned by the government itself, a lot of times it can displace communities, in Nigeria, especially communities that uh they there isn't so much wealth, so to speak. The number of persons within that community are not really regarded as wealthy or as important or influential. A lot of these projects, these projects may not even be directly beneficial to that community. They might just be, in the way, in the way of the project. And so the government would just, give a freeway pass to whatever company is handling that project. And there is little consultation with the leaders of that community, little consultation with the persons representing the community, and there is no compensation at the end of the day. There is nothing uh, to show for it that, oh, the government came through this community for whatsoever reason, and here is what you got out of it. There is nothing to show for this community. So what legal standards, or what laws do you think would be able, if implemented, to protect these affected populations and these affected communities?
Yeah, so that question is really good, and I think it's something that we are seeing in a lot of different contexts, including in Brazil. So its law is very clear that development cannot come at the expense of people's rights. At a minimum, international standards require meaningful consultation and timely compensation, livelihood restoration, and access to effective grievance mechanisms. So these are not good practice. It's not something that is good to have. They are legal expectations derived from the right to property, housing, and adequate standard of living, and access to remedy. Those are rights. Where indigenous people or traditional communities or tribal communities are affected, and giving you a Brazilian perspective here, the legal threshold is even higher. So we are talking about the ILO Indigenous and Tribal People Convention number 169 that established the obligation of companies and states going to those communities and implementing the free prior informed consent, so FPIC for short. What does this mean? It means that consultation must happen before decisions are taken, must be informed to the community, and it should be culturally appropriate. So it has to take into consideration their context, their culture, their language, and they should go there, talk to the community, see how it would affect the community, and see how can they mitigate or prevent the risks, because displacement is and should always be the last resort. And it must follow the community's decisions that are taken, and that's where the real influence overcomes. And it's not just like participation, it's not just formality, it's a right that they have be present in the decision-making process that might affect them. So in addition to that, under the UN guiding principle on business and human rights, the companies involved in the development projects, they have the independent responsibility to conduct human rights due diligence and to prevent and mitigate displacement-related harms, even where domestic enforcement is weak. So we are talking about two different responsibilities: the company's responsibilities and the state responsibilities, and they both have the duty or the responsibility to protect and respect human rights here. So the lesson from many countries, including Brazil, is that when consultation is superficial or late in the process and compensation is treated as a one-off payment, if the compensation actually happens, displacement becomes a source of a long-term conflict, litigation, and also social instability. So, in my opinion, development without enforceable rights protections is not sustainable development. It is a transfer of costs from companies and states to communities who are weaker in this situation. So I think that consultation and compensation are the basis for any development project, should be the basis for any development project. And even when states are weak and democracy is weak, or the state is not doing what it's supposed to be doing, companies must act because they also have a responsibility.
Okay. Okay, I think that's perfect. Um, okay, okay. So, okay, let me ask a follow-up question to that. So, um, could there be okay, or could you suggest, let me say, two or frame two, let's say now you were given the opportunity to be, before the Nigeria's National Assembly, where policies and laws are being made, and they asked for two suggestions uh, that could, legal suggestions that could, help in this issue. How would you frame it? How would you frame how would you frame the law? How would you frame that legal remedy that would help reduce or write out, remove this particular issue?
Yeah, so I think at first, when it comes to legal changes, at first, when we are talking about including communities into the decision-making process and making this inclusion culturally appropriate, I think that not only, I'm not sure if Nigeria has ratified Convention 169, ILO Convention 169, but should ratify it, and not only ratify, but domestically incorporate these treaty rights so courts can apply them directly. And also, when it comes to remedy, they should allocate, because it's something that is happening, right? They should maybe, that's something that, having those cases where a lot of communities are being affected, or a huge number of people are being affected, maybe they should implement some hearings or some courts specialized in the matter at hand, because the people involved are going to be in depth when it comes to the topic that are being discussed, and also the cost for the access to those remedies and for those hearings, or to participate in the justice process, should be lowered. So I think also, because as you mentioned before, when we're talking about communities, they tend to have less wealth. So make
Yes.
it the justice system more available and accessible to
Yeah.
them, especially in those situations, and especially if we're talking about indigenous or tribal communities, because we
Yeah.
know that they're more vulnerable. They should have they have different rights because of that, and they should have their rights protected. And exceptions should be made to them, because otherwise, if we treat them for example, in equal terms, like we have a saying that treat the different differently. So if we treat them in equal terms and not consider their vulnerabilities or their specific characteristics, we're still violating their rights. So we have to take that into account when dealing with those situations.
All right. That was brilliant. That was brilliant. I think if that's, oh my god. Oh my, you took the words. That was brilliant. That was brilliant. All
I'm
right.
so
So,
glad.
responsibility. Yeah, we have. If you notice the flow of these questions, we started from identifying various issues. We went on to identify vulnerable groups. We've entered corporate environments. So now let's say that we have this interview has been successful. We've successfully uh, changed or transformed the the world of human rights in Nigeria. We've made a lot of impact and we've made a lot of progress. So let's say now at this point, uh, these these less privileged groups uh, have been able to does or makes an order or a judgment in a particular human rights case. But then, even though this judgment has been delivered, it's ignored by the authorities themselves. So how can the legal system ensure that government agencies, judicial decisions?
Yeah, I think this is where rule of law becomes real. The ICCPR and the UN basic principles on the independence of the judiciary. Judicial decisions, they must be binding and enforceable. And to make sure that we have that situation under control, we can cite, for example, some mechanisms such as the content powers and personal accountability for officials who refuse to comply. Budgetary and administrative enforcement. So the parliament, for example, can require agencies to report on compliance or non-compliance and conditions funding on lawful behavior. Also, independent enforcement bodies and inspectors, where they can follow up on the decisions and make sure that they're being applied. But I think one of the most important things in any systems and any cases is transparency. So I believe that public reporting of non-compliances should be shared, but also the compliances ones, right? So it can increase political pressure or cause when it comes to non-compliances. So if a court order can be ignored with no consequences, litigation becomes symbolic. So people are wasting their time, they're wasting their money, they are being put through a super pressured system for nothing. They will stop using the judicial system. I think the reform should be implemented, and it has to build trust and transparency, and most of all, accountability as well.
Okay. That's beautiful. Although I feel this is a bit more. Okay, let me phrase the question this way. There are a lot of uh, there's a huge world of theories, regarding this. But could you give a practical, I mean, practical way, just one practical way that, regardless of the government institution where this practical step you're about to give us is implemented, it would secure 100% guarantee that this judicial decision would be executed promptly, in a timeous manner, and to the extent to which it was given, for the benefit of the person or the victim who has secured it. So a practical step, yes.
Yeah, for the practical step, I think honestly, it's not going to be easy, but it's a judicial reform. Because
Okay.
if we don't have something that guarantees that most, at least, because I'm not talking about the exception here, right? If I'm talking about the rule that implementation is not through, we have to reform the judicial system. We have
Okay.
to reform the way that it's built. Because if you were an exception, we could mention some specific tools or mechanisms to address those specific issues. So identify these specific issues that are not being implemented. But if we're talking about the rule and not the exception, we have to understand that the issue is systematic, and changing only one thing won't be enough because it's going to happen again and again. So
Yeah.
change in the judicial system is implemented, or who is ruling and who is it's following those decisions, it has to change. Because if things are not being done the proper way as a rule, we have to change the whole system. It's, as I said, it's not going to be easy. It's not one
Yeah.
thing to implement. But if it's
Yeah.
something that is so systematic, I would say that we have to start almost from scratch, to build something up that is stronger, more robust, and and that people can actually trust.
Okay, I love that. All right, thank you so much. All right, the last question before we take a break. You know, can you in brief sentences tell us about any challenges that Brazil has had over the years, and the progress they've made in that particular challenge, and how whatever mistake it was could be a lesson for Nigeria. What mistake do you think Nigeria could avoid as it builds its own human rights system?
I think I can mention two, maybe mistakes that Brazil has to illustrate this. So, reliance on formal rights without implementation. So the constitution here is really based on the Bill of Rights, and it can be beautiful. It is beautiful. We have a lot of rights mentioned there, but if the poor and marginalized cannot access courts, the system becomes unequal by design. So, and that's something that we actually see. Not only they don't have access, but they also are victims of the system that we have today, especially when it comes to criminal law. And the other one is letting security policy eclipse rights, as we were discussing at the beginning of this interview. When the public fear drives policy, emergency measures and punitive approaches, they expand fast. and they justify the means, even though they are not justifiable. And accountability becomes politically inconvenient. So I think I'll add a third here, just because it just crossed my mind, and that might be a very practical one. I think fragmented reforms. If police reform, persecution reform, courts and prisons are treated in separate ways, the system will adapt around the reforms and keep producing the same outcomes. So it's not going to change. We have to see the problem as a whole and deal with the problem as a whole. Because if we take them separately, we are never going to achieve what we're trying to achieve here.
All right, that was beautiful. Thank you so much. I think at this point, we can conclude this what has been an amazing, brilliant session with you. This has truly been inspiring. Thank you so much for your time and your insights and perspectives.
No, it was my pleasure. I really appreciate the invite, and I'm really glad that we got to do it today. So thank you again for everything, for all the questions, and and the discussions that we had. I appreciate it.
All right, thank you so much.
Thank you.